We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today, we want to look at the human rights, constitutional law, and we want to focus on human rights, the rights that are guaranteed to all Ugandans in the Constitution under Chapter 4 of the Constitution. And we are going to look at Article 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, and Article 30, the right to education. So those are the articles we are going to look at, and on each article we shall try and see if we can attach a case so that when you go through, you have really gotten the right thing you need in this video. So the Human Rights, Chapter 4 of the Constitution. Now, we begin with Article 20 of the Constitution. Article 20 of the Constitution suggests that human rights are inherent, that no one gives you these rights. You have them. The fact that you are born, these rights are given to you. No one gives you these rights. They come from God. They are inherent. That is why we must respect everybody's rights. And if you look at these inherent rights, the leading case there that we can use is the case of Reverend Father Christopher Mutikira versus Attorney General. Is a Tanzanian case, Attorney General of Tanzania. In this case, people were not supposed to vote if they did not participate through a political party. And it was held that whoever wanted to be elected to stand as a member of parliament or any position should be allowed to go, not these things of political party, not to be attached, because it is their right to participate in the affairs of their country. Their rights are inherent. It is the leading case which clearly defined what inherent rights were. Then Article 20, Clause 2 says that the state, the government, and its agencies shall respect, uphold, protect you as you enjoy your rights. That is Article 20, Clause 2. So that while enjoying your rights, the government does not give you any right. It is only supposed to respect your rights, uphold them, help you, protect you as you enjoy all your rights. That is Article 20, Clause 2. The leading case under there, we can take Claudio Wamala versus AG. Claudio was forced to write a statement, was coerced by police to write a statement, and the police court held that they were violating his right. Police is only supposed to protect you, to help you enjoy your rights, not to force you to what you're not supposed to be doing. So that is what we call inherent rights under Article 20, Clause 1 and Clause 2. Then we can go to Article 21 of the Constitution, which clearly states that everyone is free from any form of discrimination, that there should be equality. And Clause 1 particularly says that everyone should be free from all forms of discrimination, whether political, social, economic, cultural. Everybody is free from this form of discrimination. No one should discriminate you in any form. And then if you go to Clause 2 of Article 21 suggests that everyone should be free from all forms of segregation, discrimination, from all forms of, in form of age, sex, color, disability, and others. So you see, the point is Article 21 is protecting us from being discriminated. You have a right to enjoy anything in this country without anybody segregating you. And the leading case we normally use Longwe versus Intercontinental Hotel. It is the Zimbabwean case. In this case, a woman long way went to enjoy one of the clubs, one of the hotels, but because she came and they told her to enter here, you must have a man. Without a man, you cannot enter in this hotel. So she stood on grounds of segregation or discrimination, and the court held that it was her right to enjoy any services in our country. They needed not to have told her that to enter here, you must have a man. So we normally use that as a leading case, but still we can include Sharon Dimanche. You know, this one is a locus classicus for worshipping, but it also comes to segregation. Sharon Dimanche versus Makerere University. They were alleging that teaching on Saturday when they had gone to worship their God being Adventists, that this was discrimination, that they were being discriminated, one from the right to enjoy education under Article 30. So that one also becomes a case we can use. Sharon Dimanche and others versus Makerere University and Longwe versus Intercontinental Hotel. Then we can proceed and look at Article 22. Article 22, the right to life. That it says that no one should take away the life of another. That no one has that capacity to take away the life of another unless it is by a court sentence. If it is the court that has sentenced somebody to death, then that one can be executed and it is okay. But where somebody, whether negligently or intentionally, takes away a life of another, that one is not accepted. Then clause 2, about the life of the unborn babies. It is a crime. Now, the leading case here, we have one leading case, which is Susan Chigula and 416 others versus Attorney General. A colleague was asking me, the 416 others, where were they sitting in court? But it was there, they handled. Now, in Susan Chigula, they were sentenced to death. Now, they appealed that the manner in which they had been sentenced, for example, they had said that they should be hanged. Now, the manner and the long waiting, they waited for so long, now subjected them to torture. Remember, as we come, Article 24 talks about inhuman treatment, torture being prohibited. Now, the sentence alone of death and the long waiting, thinking about the method, how they were going to be killed, compelled the Chief Justice then, Bart Katurebe, who wrote and sent the sentencing guidelines to all judges in this country, and told them, while executing our duties, because we have to protect Article 22 of the Constitution, let those sentencing people to death, let that be the rare of the rarest in the sentencing guidelines, which were set by the Chief Justice Bart Katurebe, as he was then, that the sentence of death should be the rare of the rarest. You can now see other people now who are being sentenced because we are trying to protect the life of people, and now the judge will say, I sentence you to 100 years. I sentence you to 150 years. Meaning that we have sentenced you for 120 years in prison, but it is rare occasions that somebody may reach that age. So ideally, you would die a natural death, ideally, a natural death, but not sentencing you to death. So that is how we are protecting the constitution by not allowing anyone to take away the life of another. Then we can now focus on Article 23. Two things happen, of course, in third year and then second year, third year especially, and others. People will go deep into these articles 23, 28 to continue to appreciate them. But at this level, first year, two things. Everybody has a liberty. 23 is about liberty to enjoy anything in this country. Now, but your liberty can be taken away only if you are under sentence. You don't say it is my liberty to do this, my liberty to do this, but where you are under a sentence, then your liberty can be scrapped away from you. That is what Article 23 talks about. That you have a liberty to apply for bail. You have a liberty to know the charges which are being put against you. You have a liberty to, it is your right as a person. But the moment you are sentenced, you have a liberty to enjoy any place in this country. You have a full right of liberty. But the challenge is your liberty can be taken away from you. And we have a case there. Sajabi Christopher Sereko versus Attorney General. Court held that failing to tell him the case, the charges against him, what he had done, then by police and others, then that was violation of his right, his liberty. He has the liberty, right to know that why are you charging me under Article 23.3? Why are you charging me? Why am I here? I have a liberty to a lawyer. The moment any law enforcement, police or others, deny you a lawyer, deny you a chance to be told why you have been arrested, then they have violated your right to liberty. Remember, we said under Article 20, Clause 2, that the state, its agents, government, their only role is to protect you as you enjoy your right. That is why we have a full Article 28, which talks about from Clause 7 to 12, the principle of legality. But you have a right to know. It's your liberty. Know why you're being arrested. Ask for a lawyer. Remember the other day when Bobby Wine, His Excellency, the President of NUP, when he was arrested in Glue, in Arua, brought, nobody was supposed to visit him. No one. They never allowed him, put him in the barracks in Makinde here. But when the wife came, and the lawyer Lukwago, they were given access. You have a right, a liberty, to access your doctor in case you are incarcerated, arrested, to access your lawyer, to access your family at any time. So that is Article 23. And we have said the leading case we can use there is Christopher Sajabi Sereko versus Attorney General. And then let's go now to Article 24. 24 says that in human treatment, that everybody should be free from the degrading, inhuman torture. That any acts which are degrading in nature, any act which subjects somebody to torture, all those acts are prohibited under Article 24. And we have two leading cases there. We have the case of Susan Chugula and 416 others versus AG, Attorney General. Remember I said earlier that Susan Chugula, their sentence was death, but the long waiting for them to execute, court ruled that this was subjecting them to torture. And those who watch now Susan Chigura is now a lawyer who studied law from the prison and completed through scholarship and is there in prison because now they are there for the whole rest of their life. Now, but we are saying that torture, that you sentence us to death by hanging, for example. The long waiting is subjecting us to torture. Yet Article 23 says that no one is supposed to be subjected to torture. Then another Locus Cascas case, which actually led to the abolishment of corporal punishment and punishing students and others, is Simon Chamanywa versus AG, who was beaten by a teacher, and the court ruled that it should be paid damage, and that is when the corporal punishments were all prohibited under the case of Simon Chamanywa versus AG. Locus Classicus, read it and appreciate the case of Simon Chamanywa versus AG. It was Western Uganda there. That is Article 24. Let's now cross to Article 25 of the Constitution. Now, Article 25 talks about forced labor, being free from forced labor, slavery, and servitude. Now, under Article 25, nobody should be subjected to forced labor unless when you are serving is a court sentence, you are arrested. That way, that can happen. You can't say we are in prison, we are sentenced, and now they are telling us to dig. This is forced labor. You cannot, because there you are convicted. You know, we said your liberties, your right can be taken away from you if you are convicted, and if you are serving a sentence given by a competent court. Now, let's look at slavery and forced labor. All are not accepted under Article 25. So let's look at the case of General David Tinyafunza, Major General Tinyafunza versus Attorney General. Tinyafunza wanted to resign from the army, but the president, through then Prime Minister, Minister of Defense, Ama Mbabazi, wrote a letter denying him the opportunity to resign. And the Justice Emeritus Professor George Kanyamba put it right and said that where you maintain Sejusa, Tinyefunza, to continue in the army against his will, that he says, I want to resign, and you will deny him the opportunity to resign, and he continues to serve, you would be serving him, you will be working under forced labor. You would have subjected him to forced labor. Yet Article 25 suggests that no one should be subjected to any form of forced labor. And eventually we saw the government giving in and allowing Major General Sejusa Tinyefunza to resign from the army. So that is the leading case there we can use in terms of forced labor and slavery and servitude. Now, we go to Article 26. This is the right to own property. That 26 says everybody is supposed to own property. It is your right to own property. But again, it takes away this right from you. How? That where government needs to use that property in question, for example, land, the government can acquire that land, but still it sets the criteria how government is supposed to acquire that land to compensate you. You are supposed to be compensated before the land is taken. And of course, if you second year you do land, and then you read the Acquisition Land Act Section 3 to Section 7. It gives you a procedure that government is supposed to follow before taking away your land, the land from you. Okay, so, but the ground point is that everybody has a right to own property. No one should deprive you of your right to own that property. It is your right and you must own that property. We have a case there. Julius Okot versus AG. It was another Uganda case. The army wanted to take over and construct a military barracks or Tashin Glue in northern Uganda. So Julius Okot gave in his land. They wanted to take his land and he accepted, but they took over the land and they never compensated him. So he went to court. Court ruled that no one should take away, deprive another of a right to enjoy or to own their property unless, in case of government, they have compensated that person. And therefore, court ruled that Julius Okot should be either be given his land or compensated for the loss of his property. So that is Article 26. In the case there, Julius. And then we have also a case of Salvatore Aboki versus Attorney General. Remember, when they were banned from the village, they also wanted to take their property. Court ruled that no, you cannot punish them twice. They have been pursued on 10 years, and then you take their property. This is where they go their food from. And remember, they have a right to own their property. So also, Salvatore Aboki versus AG is one of the other leading cases you can use in terms of property. But members, read these cases and appreciate them very well. Let's go to Article 27. The right to privacy. That everybody has a right to privacy. That no one should encroach on your privacy. For example, no one should come and enter your house. If it is the police, they must have a search warrant. That your property is your property. You see, there is no mistake that right to property is coming in 26 and right to privacy is coming in 27. Remember, in law, what comes first takes precedence. But look at this. 26 is property. That after you have owned your property, no one should just encroach on your property. You have a full right in the Constitution of privacy under Article 27. No one should encroach, disturb your peace. Let's look at the case of Kings versus Friends. Friends is T-H-E-R-E-N-S. King versus Friends. Now, the Canadian Supreme Court ruled that the idea of police entering King's house without a search warrant and they check his house, they were violating his right of privacy. You cannot. They're going to send you those to set for you the problem questions, saying he was arrested and the police got him, they went, entered his house, searched it. The issue is, they entered, where did they have a search warrant? If not, they have violated his right of privacy. Then Article 28 of the Constitution, fair hearing. Fair hearing. It has the principle of legality in there. Fair hearing, Article 28. What do we mean by fair hearing? That everybody has a right to be heard, a right to defense, a right to submit. You know that when we are in court, we must listen to both sides. Fair hearing, they must listen to you. Yes, you have committed a crime, but tell us why. They should accord you fair hearing. Of course, this one we shall expound more. But of course, we're talking about peace of legality, and here, clause 7 to 12 talks about peace of legality, and then we shall expound when we are doing natural justice in second year administrative law, and then we expound. But the underlying principle is everybody must be accorded a fair hearing. Like Justice Bart Katwebe put it, that fair hearing is the mother of all laws, which must be respected in the case of Betty Namboze versus Bakalwa Mukasa. But everyone, this is the mother of all laws in this country, that everyone should be subjected to a fair hearing, and very many other cases. Let's go to Article 29. Freedom, free from freedom of expression, freedom of speech, freedom of assembly, freedom, right to demonstrate. All these rights are under Article 29. And members, look here. When discussing them, the problem question will tell you the people have assembled. Then police is disturbing assembly. Look at the case of Mwanga Chivumbi versus AG in terms of assembly, where Section 32 of the Police Act was scrapped off. Remember, it has given the IGP powers to suppress assemblies at any time, the way he wants. So it was scrapped off. Mwanga Chivumbi versus AG assembly. Then we have freedom of movement, that you have a right to move anywhere in your country. Look at the case of Kizza Besigye versus Civil Aviation, where he was denied to leave the country, and court ruled it was violation of the right to movement. Look at demonstrations, look at speech, Andrew Mwenda and another versus AG, where seditious intention and seditious offense under Section 39(1)(a) and 41(b) of the Penal Code were scrapped off because they were inconsistent with Article 29, which gave people their freedom to write. So basically, look at Article 29 as a whole and look at all those sections, clauses under Article 29: speech, assembly, movement, demonstration, and others. And then finally, Article 30 of the Constitution, which clearly talks about education. You have a right to education, and the leading case there is Shaun Dimanche versus Makerere University. Let's have a close look at that case, appreciate it, and then you'll be able to use it when you know it. So, in a nutshell, that is the.
There is also LDC.
Oh yes, there's also the case of Pius Nwagaba versus the LDC, where Pius was refused admission because he had come from Pentecostal University, which had not been legalized by law council. So court said no, allow him to enter LDC. You as LDC, you should set your own rules of admission. Don't base on law council. So that is how Pius was able to be admitted. So look at Pius Nwagaba case, and then Shaun Dimanche case in terms of education, and then you will appreciate these human rights and very many others. But for first year, second semester, constitutional law, Those are the normally usually asked areas in the problem question. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Thank you so much.